Anytime a person is arrested, the judicial process is set up that there are 3 stages. The first stage being probable cause. For a person to be arrested, there must be probable cause to effectuate that arrest. That can be determined by a police officer, or it can be ultimately determined in issuing an arrest warrant by a judge. Probable cause means it's more likely than not that a crime was committed and that you are in fact the person who committed that crime. It is a very low standard, and it is merely the precursor or a quick glance at the alleged criminal activity. Once you are arrested, your case will be presented to the grand jury. This is a group of individuals, they're citizens from your community, who meet in private, and you're not allowed to be present. Your attorney cannot be present, and it is solely a procedure in which the solicitor or the prosecutor calls witnesses. It could be the arresting officers or other officers involved in your case, and they will present it to these citizens of the community. They will return either a true bill or a no bill. A no bill means your case is dismissed. A true bill means your case will proceed. At that time, you will go to what's called the trial process. At each stage, the criteria is a little higher because at a criminal case or trial, you have a right to have 12 independent members of your community judge your case. In magistrates court, 6, and they must find you guilty unanimously and beyond a reasonable doubt. Later on, we will have a video about the alternatives to trial, but it is always your constitutional right to demand a jury trial. You will never be punished for exercising your right to have a jury trial. Now, it is true that many times it may appear that way because you will get a lighter sentence if you plead in front of a judge. In fact, you're not being punished for exercising your right to a trial by jury, but in fact, you are being rewarded because you have owned your crime or fessed up to it, so to speak, and you get a little bit of a bonus. You do not have a choice in the judge that you will have. That is determined solely by the solicitor, nor do you have a choice at which time your case will come to trial. That is, again, solely within the provinces of the prosecuting agency or the solicitor. Your attorney and you will be allowed to participate in the jury selection process. You will learn a little bit about jurors, and it is a misnomer. People think you pick who's on your jury when in fact a certain number of people like in a criminal case where there's 12 jurors, names will be picked out of a hat, and both the prosecution and the defense can have up to 6 strikes, which means 24 potential people, and if both the prosecutor and your lawyer strike 6, the remaining 12 will become the members of your jury.